welcome to the 2021 Bench Bar Faculty Conference. We would invite our sister, Mrs. Acheampong, the National PRO, to give us the opening prayer.
Kindly rise for a word of prayer. Gracious God, we are grateful to you for today and for making it possible for us to meet. We thank you for the lives of the members of the bench, bar, and lawyers in academia. Dear God, keep us safe at all times, and may your favor rest upon us. Bless us, dear Lord, and establish the work of our hands. May your presence be with us as we deliberate on matters relating to our professional development. Thank you for answering our prayer in Jesus' name. Amen.
Thank you very much, Mrs. Acheampong. We'll now take the opening remarks from His Lordship Paul Boafo, representing the Chief Justice of the Republic this morning.
The program says Justice Yeboah, the Chief Justice. So I wanted to alert you that I am not Justice Yeboah. He is a very big man. So physically, I can't even feel his space. My lords, justices of the Superior Court, the Honorable Attorney General, President of Ghana Bar Association, the Dean of the School of Law, University of Ghana, the Rector, Ghana Institute of Management and Public Administration, members of the bar, invited guests, good morning. On behalf of His Lordship, the Honorable Chief Justice, I formally welcome you to this conference. The annual legal year bench, bar, and faculty conferences have become a pivotal point, enabling the various stakeholders in the justice delivery system to converge and explore best practices in professional and legal development. This year, as the world grapples with the COVID-19 pandemic and its tsunami-like effect on how systems and processes are conducted, the legal profession has not been spared. A conference at this time is therefore most appropriate. Justice delivery in these times of technological advancement has meant that various jurisdictions have had to innovate to ensure that the mandate of justice delivery is still accessible, efficient, and adaptable. This means that legal education and professional development must also change to remain relevant in a dynamic world, increasingly driven by technology. In Ghana, the judiciary has for some time now anticipated the need for the use of technology to augment the delivery of its traditional mandate and has worked progressively to ensure that it is equipped with the necessary logistics and technology. This is evident by the fact that longhand writing in record books are giving way to computers and digital interventions such as the e-justice paperless projects and the virtual courts are being piloted. The use of technology, as demonstrated by the recent use of Microsoft Teams and other social media platforms in the recent election petition, among others, shows that the judiciary is adaptable and not averse to the use of technology to sensitize, educate, and demystify legal processes. The importance of technology in these times is giving birth to a different kind of legal professional, one who is IT savvy and able to meander between traditional ways of delivering services and the fast-paced technological demands. This concept of a court is also evolving. Legal professionals must possess new skills to meet the demands of an increasingly IT proficient clientele. The structure of the traditional mode of lawyers taking in-person instructions have changed. These changes bring with it the need to ensure that ethics and professionalism are not sacrificed at the altar of speedy justice. Virtual calls have become the norm in some jurisdictions, whilst meetings as well as teaching and learning are predominantly being held virtually in most places of legal training. The legal profession across the world has by and large adapted its processes and procedures in the light of the general restrictions that have been imposed due to COVID-19. Knowledge professionally and make use of the myriad of professional development opportunities to enable the legal profession continue to perform its role of increased access to justice and hold on to its position as one of the bastions of democracy. Thank you for your kind attention, and I wish you a successful conference.
Thank you very much, His Lordship Justice Bafo, today representing the Chief Justice of the Republic of Ghana. Will now invite the Honorable Attorney General, Honorable Godfred Yeboah, to deliver his address. Now, welcome back, everyone. We've now had our issue resolved. So we invite the Honorable Attorney General to give us his remarks.
My lords, permission to take the opening statement again. His Lordship Justice Paul Boafo, representative of the Chief Justice of the Republic of Ghana, Justice of the Superior Court of Judicature, Magistrates of the Lower Bench, Mr. Anthony Forson, referring to the Ghana Bar Association, my two lecturers, Professor Raymond Atuguba, Dean of the Faculty of Law, West of Ghana, Professor BONDZI-SIMPSON, Rector of the Ghana Institute of Management and Public Administration. Distinguished guests, ladies and gentlemen, I am pleased to be called upon to deliver the opening remarks. The remarks at this bar bench faculty conference. Being my maiden appearance at such an event, since being sworn in as Attorney General and Minister for Justice, I can only hope for fruitful collaboration with the three components of the legal profession in Ghana: the bar, the bench, and the academia. My lords, this forum is a manifestation of the commendably close ties that bind the judiciary and legal practitioners in Ghana. Warm bench bar relations are generally accepted around the globe as desirable in a constitutional democracy as ours. Regular engagement between the judiciary and the legal profession on their aligned interests can only be a vehicle for the delivery of fair and effective justice. Indeed, the gathering of lawyers and judges symbolizes the dynamism, diversity, and hopes of society. The fabric of society depends on legal rights and obligations, benefits and burdens being validly created and effectively enforced. Representing all kinds of interests, from the vulnerable to the global giants, lawyers and legal profession are as integral to the administration of justice in the world as the dispensers of justice, the judiciary. The organizers of this forum thus deserve utmost commendation for putting together the event. The array of speakers assembled and diversity of topics for the two-day conference strike a good interdisciplinary balance, healthy for a sound continuing legal education. My lord, the relevance of the theme for the conference is more than apparent. It is worthy to state that data transformation has taken the world by storm. Legal tech is turning out to be an inevitable tool for the execution of functions of a lawyer, the world in point of fact is becoming unavoidably virtual. For the extremely conservative, and as I call the impervious to change lawyer, my humble admonition is that advances in automation, technology-assisted reviews, artificial intelligence, and legal technology generally are all about ensuring that clients will want to stay with you and lawyers will want to work with you. In effect, a failure to embrace technology and develop oneself professionally in the virtual world implies extinction of one's law practice. So if you do not develop technologically, your clients will leave you and the lawyers will refuse to work with you. Professional services are rapidly changing and have to adapt in response to disruption forced upon by technology. The prospect of improved productivity and reduction of costs would ensure that in no time, legal technology will take over many of the functions that junior lawyers traditionally used to perform. It's in this regard that I'm happy to say that the Office of the Attorney General and Ministry of Justice is going fully digital within 1 year. The Integrated Information Management System and Digitization Project, a World Bank funded program under the auspices of the Ministry of Communications and Digitization, is near completion. In line with discussions with the contractors last week, the information management system will proceed to the go live stage. When fully rolled out, various components of the program will facilitate a data handling of all cases brought to the Office of the Attorney General and other tasks the office is charged with under the Constitution. It will also result in electronic management of all records at the office. Fully cognizant of the supreme benefits of technology, I am in discussions with the contractor to augment the capacity of the project by adding a fully functional modern electronic law library to the program. My lords, I need to place on record that the launch by the judiciary of the legal web library last year, as part of a series of interventions in the justice delivery sector, using information communication technology as a tool to access legal materials and other valuable legal materials needed in the justice sector, represents a giant move by the judiciary in the right direction of digital evolution. In case of education, the onset of the COVID-19 pandemic indeed resulted in a number of initiatives by the court to enhance administration of justice in a healthy environment. I dare say that the court ought to examine the lessons learned as a result of the pandemic with a view to making some of the temporary innovations permanent. Especially the professional development of a lawyer to rise to the demands of a virtualized world cannot be overemphasized. A poorly trained lawyer is a danger to society and a threat to the sustenance of our democracy as a nation. Just as a virtually just as a virtualized world implies that a small online business is exposed to rules and regulations outside this country's borders, the local jurisdiction in which law is practiced also becomes open to the world. Our lawyers have to be world class, working as part of an open global community to resolve modern day disputes, as part, many of which have a cross border element. There's a need to work to make Ghana a highly respected home for arbitration in Africa, whose arbitration awards are enforced effectively around the world. The time has come for us to respond to the dictates of Section 114 of the Alternative Dispute Resolutions Act 2010, 798, by setting up a Ghana Alternative Dispute Resolution Center, which will provide a modern, reliable, and business-friendly mechanism for resolving investment and commercial disputes in the country. I commit myself to same in my tenure as Attorney General. In addition to the raw legal knowledge, the acquisition of knowledge in vitally related fields by the modern lawyer is very necessary. If you are a corporate lawyer, you may have to learn a bit of project finance. If you are a litigation lawyer and take up litigation in the construction of infrastructure, familiarity with various infrastructure dispute models will come in handy. Ultimately, the business aspect of the law is also important. It is one thing to be a lawyer with all the legal knowledge, and another thing to run your firm as a business with sustainable employment for many people from various fields: law, accounting, engineering, and construction. My Lord, I cannot conclude these remarks without adverting our minds to the dangers and hazards of a virtual world. I am particularly delighted that space has been reserved for a discussion of ethics and technology by Madame Victoria Bath. I would urge lawyers to be mindful of the age-old requirements of the profession insofar as ethics is concerned. Technology did not eradicate ethics, neither did it render the need for ethical compliance any less important or necessary. Lawyers use social media to exchange information and thereby market their expertise. Spread of false information by lawyers and disregard for the cherished virtues of a legal profession, apart from being disputable, poses a far greater threat to cohesion society if it comes from lawyers. Ultimately, a dishonest bar, they say, breeds a corrupt bench and affect the core society we seek to build. Ghana cannot afford to gamble with its future by sacrificing the time-honored noble attributes of legal profession on the altar of technology. It's my hope that between today and tomorrow, your interactions will not only deepen the cordiality of relations between the bar, bench, and faculty, but we shall also leave the conference the richer in terms of the wealth of knowledge gained from listening to the various distinguished and accomplished lecturers on the topics with which they are attached. God bless you. Thank you very much.
Thank you very much, the Honorable Attorney General and the official leader of the bar. Our next speaker has been a visiting professor of law in the Henry J. Steiner visiting professor of human rights at the Harvard Law School from 2018 to 2019, and has taught 37 courses at several universities in Africa, Europe, the United States of America, and Australia. His research interests are in constitutional administrative law in the Global South, law and development in Africa, and human rights and community lawyering. A graduate of the University of Ghana and Harvard Law School, where he obtained a Master of Laws degree and did doctoral studies. He has also worked in the public sector and was one time the Executive Secretary to the President of the Republic, the private sector, where he was the team leader of Law and Development Associates and Atuguba and Associates, and the non-profit sector. He is the co-founder and former executive director and former board chair of the Legal Resources Center. He has over 100 publications, been engaged in over 100 research and advocacy projects, produced over 100 research and technical reports, and has delivered over 300 papers and presentations on all continents of the world. He has consulted for many African governments, Gambia, Ghana, Lesotho, Liberia, Sierra Leone, Uganda, Zimbabwe, and many others, and major international development agencies and NGOs, the United Nations, UNDP, the World Bank, IOM, AU, ECOWAS, USAID, DFID, GIZ, Danida, Oxfam, EBIS, IIED, Action Aid International, Human Rights Watch, Care International, Plan International, and many others, and led or co-led over 30 training programs and workshops. He has also chaired or sat on over 50 boards and committees, and currently is the Dean of the University of Ghana School of Law. Ladies and gentlemen, presenting Professor Raymond Akongburu Atuguba.
The representative of the Chief Justice, Justice Paul Boafo, their Lordships, Justices of the Superior Court of Judicature, the Honorable Minister for Justice and Attorney General, Honorable Godfred, Yeboah, the President of the Ghana Bar Association, Mr. Anthony Forson Jr., Plenary Speaker, Professor EBOW BONDZI-SIMPSON, colleague deans and law lecturers in Ghana, other judges, colleague lawyers, invited guests, media operatives, ladies and gentlemen. I thank you for this opportunity to give a few remarks on behalf of the ever-growing faculties of law in Ghana, and at the beginning of an important gathering of the bench, bar, and faculty to deliberate on matters that affect our common weal. The theme of this gathering, professional development in a virtual world, emerging trends and best practices, is not only important, it is determinative of the future of legal training and professional development in the decades to come. As part of the faculty, I will naturally contain my remarks within the reality of the new normal for our branch of the legal profession. In this regard, I wish to make three contributions to the theme of this conference. The first is that virtual teaching and learning should be complementary to traditional in-person teaching and learning. The second contribution I wish to make, as already noted by the Acting Chief Justice for this session, is that virtual teaching and learning requires heavy investment in ICT infrastructures of a kind that has not been seen in our law faculties before. And the final contribution I wish to make is that an appropriate blend of traditional and virtual methods of learning and teaching implicates a refreshing of teaching and learning curriculums and methodologies that we have been comfortable with in the last 60 years. So my first point, virtual teaching and learning should be complementary and auxiliary to teaching and learning methods. The first suggestion I seek to convey is that virtual teaching and learning should be complementary to traditional teaching and learning. Put another way, traditional modes of teaching should remain the main forms of instruction and learning. We must remember that the legal profession is a profession, and professional training always implicates apprenticeship, and it is difficult for real apprenticeship to occur completely via long distance or virtual training. Again, some of the learning that we want for our students to pick up: observing the countenance of witnesses, assessing the truthfulness of a witness, anticipating the arguments from the other side. Real advocacy that utilizes all the senses are really difficult to do virtually. For a year, we have taught virtually, often with our videos turned off, not seeing our students, not knowing if they are listening, not able to judge from their countenances if they understand, or from their general disposition if they need extra help. The avenues for fully observing students' composure, demeanor, and reactions, as is required for a full evaluation of the would-be lawyer, are simply not fully available in virtual learning. Also, the task of training a lawyer invariably involves observing the would-be lawyer closely, both in and outside the classroom. The virtual experience falls short of the imperative that the lawyer in training is seen in action and in behavior in a suitable setting and environment in order to judge their temperature, composure, voice, and demeanor in our rather unique calling that requires the best of manners and calm in the most vexing situations. It is for these reasons that many top law schools around the world are planning to go back to the traditional modes of instruction come next academic year. I must quickly add that virtual teaching and learning should be an indispensable complement to traditional modes of instruction. Thus, legal education is not complete without virtual teaching and learning. Our students must be able to join classes taking place around the world, access law material from around the globe virtually, and interact with teachers and other students from all over the world virtually in order to obtain a well-rounded and truly global legal education. To conclude on this first point, the pandemic compulsorily moved law teaching from the physical classroom onto virtual platforms. And after a year of virtual teaching in Ghana, I am convinced that effective law teaching requires both lecturer and student to share the same physical space and presence most of the time. I am further convinced after a year of virtual teaching that the traditional modes of instruction stand to gain a lot if they accommodate aspects of virtual teaching and learning. In other words, a mixed hybrid method of teaching law involving the two methods, the traditional and the virtual, should be adopted even post-pandemic. I have been the greatest advocate for virtual learning of the law in Ghana. I am happy that the new AG is thinking of doing same for the AG's chambers. I, however, maintain that virtual teaching and learning should remain a complement, even if an indispensable complement to the traditional mode and standards of teaching law. Though inadequate by itself, virtual teaching has the potential of optimizing the traditional teaching methods. The two methods, therefore, would be best for the training of the Ghanaian lawyer in the 21st century. Now to the second point I seek to make today. Virtual learning entails unprecedented heavy investment in ICT infrastructure by law faculties. In several instances in the University of Ghana, where I work, the internet connection was not stable for lectures, pausing and interrupting the flow of lectures. The cause of the fluctuating internet connectivity was traced to rats that had eaten the fiber optic cable. Even after rectifying that problem, we are now trying to extend the fiber optic cable from a private company already in part of the university to our school. This is to provide a backup fiber internet option to the unstable one we currently use, and additional to the 3 private wireless backup systems we have installed. These and other challenges subtract substantially from the quality of the teaching and learning experience that students encounter. There is no escaping the fact that law faculties in Ghana must immediately generate the millions of Ghana cedis that are needed to lay the appropriate ICT infrastructure for training the lawyers of the 21st century. Please remember this when we come to you beginning this month for your contributions as alumni to these and other endeavors. The last point I seek to convey today is the need to refresh curriculums and teaching methodologies. Blending the traditional and virtual learning methods requires changing the curriculums and the teaching methodologies. We need to urgently revise our course outlines. We've completed that at our law school already, and reevaluate and restructure the content to accommodate the two teaching methods. We need to revise the reading lists with the assumption that virtual learning means that material from around the world is accessible to the students, sometimes even on Google. We need to develop standard textbooks. Law lecturers must be awarded research grants, Attorney General, to produce these books immediately in order to bring life to the dry course outlines and reading lists. We urgently need to refresh the teaching methodologies, for it cannot be that the same inherited methodologies are still the very best after 60 years, and in a situation where virtual learning is being mainstreamed. And finally, we need to modify the training and orientation of law teachers, ensuring that they are open-minded, willing to embrace change for the better, and a blend of the two modes of teaching. We hope to discuss all of these matters I have detailed here in Ghana, to which you are all invited, at the Law Conference of Law Deans. It's actually Professor BONDZI-SIMPSON who encouraged us to continue with that. And at the Law Teachers Conference, to which law lecturers would attend. Because faculty are tasked with the primary responsibility of implementing any new teaching methods adopted at these conferences, it is expedient that they must be consulted every step of the way in the process of renewal and rejuvenation. My Lord, the Acting Chief Justice, Your Lordships, Honorable Attorney General and Minister of Justice, Plenary Speaker, esteemed guests, media, ladies and gentlemen, I thank you for your attention.
Thank you very much, Professor Raymond Atuguba. We now invite our own national president, Anton Forson Jr. Esquire, to give us.
the representative of His Lordship, the Chief Justice, Justice of the Supreme Court, His Lordship Paul Boafo, my lords, honors and worships, Honorable Attorney General Mr. Godfred, the Rector of GIMPA, my senior and infant Professor P. EBOW BONDZI-SIMPSON, past presidents, members of the Bar Council, distinguished members of the Ghana Bar Association, present, and all our colleagues joining us virtually, our friends from the print and electronic media, ladies and gentlemen, I consider it a rare privilege for me every time I have the occasion to address you, be they brief remarks or long speeches. The first ever bench bar and faculty conference was held in 1967. It was then referred to as lectures. The aim of the visionaries at that time was to create a useful opportunity outside the formal atmosphere of the courtroom for judges, practicing lawyers at the bar and industry, as well as those engaged in the teaching of law in the faculty, which at the time was only legal, to meet for a free exchange of views and on diverse issues affecting the legal profession, administration of justice, the rule of law, and the governance of the country generally. Even though the original intention was to hold the conferences annually, it is very sad to report that in 54 years, this is the 8th event. Indeed, after going into limbo for about 30 years, a half-day event was organized in 2013, the rule of law in Ghana. Lawyers and academics who have stood for it and judges who have died for it. What role do you play? These conferences over the years have been addressed by distinguished jurists, academicians, and practitioners within the legal profession who devoted time and energy during the sessions, brainstorming on law reforms and emerging issues affecting the administration of justice. In his opening remarks at the 2015 conference, the GBA president at the time, Nene Ofue Amagache, now Amagache GSC, said, quote, "The historic conference is the beginning of a renaissance within the legal fraternity. The conference, in my opinion, is critical to our democratic survival, the sustenance of the rule of law and good governance in this country. Let this rebirth be hailed by all with a pledge that the yearly bench, bar, and faculty conference, closing with a black tie dinner dance, has come to stay," unquote. In 2019, we managed to secure the tacit agreement of Her Ladyship, the former Chief Justice, Sofa Akufu, that the bench bar faculty conference will thenceforth be a calendar item, and it will fit snugly in the week immediately following Easter, when the courts will be on vacation as per Order 79, Rule 4A of CI 47. We are grateful to the judiciary for their cooperation. Unfortunately, we were unable to have the conference in 2020 for obvious reasons. In 2019, I indicated that it was my administration's vision and dream to reform the bar using technology. That dream has been realized, and today, through the use of our own resources, these sessions will be beamed live to all members in good standing who would log on to the bar portal. Ladies and gentlemen, we are grateful for your encouragement, support, and of course, criticism. And I can assure you that by the end of my term in September this year, September this year, we would have fully developed a local solution for continuing legal education, even though we have had to import some technology. It is important to observe that Section 84.1 of LI 2423, that is the Legal Profession, Professional Conduct and Etiquette Rules 2020, with a gazetted notification date of 6th October 2020, provides, quote, "A lawyer who holds a practicing certificate issued by the council shall A, complete a minimum of 12 hours of continuing professional development in a calendar year." Ladies and gentlemen, the bar has readied itself to offer its members that support to achieve the requirements of the law. My lords and learned colleagues, a healthy relationship between the bar, bench, and faculties is a sine qua non for the growth of the profession and the confidence of the society in the legal system. In the aftermath of the 2020 elections and during the just ended election petition, some lawyers, unfortunately, made statements which did not go down well with the generality of the legal fraternity. And indeed, a former Deputy Attorney General had to appear before the Supreme Court on a contempt charge. He did apologize, and His Lordship, the Chief Justice, had words of admonition for us all, which we took on board with open minds. Indeed, three other lawyers, Messrs. David Annan, Abraham Amaliba, and Dr. Bassett, were also hauled before the disciplinary committee of the General Legal Council. But the bar representatives on the General Legal Council made an intervention for clemency, which was supported by His Lordship, the Chief Justice. Led by myself and the former Attorney General, Marietta Brew of Acheampong, we appeared before the disciplinary committee chaired by His Lordship, Justice Boafo, and after written apologies, we were advised to remember that in every situation we found ourselves, we should always act in ways which uphold the dignity of the profession. We would once again like to express our appreciation to His Lordship, the Chief Justice, for his role in maintaining the good relationship between the bench and the bar. Thomas Jefferson, the distinguished author of the Declaration of American Independence, said, quote, "The dignity and stability of government in all its branches, the moral of the people, and the blessing of society depends so much upon an upright and skillful administration of justice. Judges, therefore, should always be men and women of learning and experience in the laws, of exemplary morals, great patience, calmness, and attention. Their mind should not be dependent upon any man or body of men," unquote. It would be remiss of me, on my part, not to bring to the attention of this conference the issue of competence. Article 1461 of the Constitution states, quote, "A justice of the Superior Court or a chairman of a regional tribunal shall not be removed from office except for stated misbehavior or incompetence on the ground of inability to perform his functions of his office arising from infirmity of body or mind," unquote. Information reaching me from lawyers indicate that some judges, even in the simplest applications, demand written arguments. Indeed, in one complaint which I received from a very senior practitioner who has given me his blessing to mention his name, Charles Yeboah Esquire, now Togbe Teprehodo, a judge was demanding written legal arguments from a lawyer in an injunction application after the lawyer had filed his motion paper, the supporting affidavit, and his statement of case. Why would you put a practitioner through such stress? There are also occasions of unnecessary long adjournments for rulings in simple applications which should necessitate a bench ruling. All this smack of incompetence and must cease forthwith. Equally unacceptable is incompetence from counsel in these days of technological advancement. It is unfair to the client and to the profession. Indeed, what has occasioned the addition of the topic on the pitfalls in invoking the supervisory jurisdiction of the Supreme Court, a topic which the Bar Association has painstakingly flogged over the recent years and which has seen a lot of judicial pronouncements, was my personal experience in the Supreme Court in February this year. Every single application invoking the supervisory jurisdiction of the Supreme Court, including the one against my client, was dismissed. The situation occasioned a complaint by the president of the panel, Jones Doche JSC, to query me about why the bar doesn't seem to be able to overcome these pitfalls. Our colleagues in the faculties are also cautioned to do their best to train the undergraduate law students such that not only will they qualify into the law school in greater numbers, but come out as fine graduates capable of being molded into fine, competent, and ethical lawyers. Mutual respect, forensic language, judicial comportment, honesty, and integrity are indispensable ingredients in the relationship between the bench, the bar, and the faculty. Let us all strive, no matter how trying the circumstances may be, to keep the nobility and dignity of the profession which has been bequeathed to us and handed over to succeeding generations in as pristine a condition as our fathers left it. I thank you for your attention.
Thank you very much, National President Anthony Forson Jr. We now come to our plenary session. And our speaker is a full professor of law. These days, you have to be very sure about that word, because you can get it in 3 months. Okay. He holds a Bachelor of Laws honors degree from the University of Ghana, 1994, a Master of Laws degree from the University of Saskatchewan, SJD from the University of Toronto, PGDE from the University of Cape Coast. He's a former lecturer at Ghana School of Law, former Director of Legal Investigations of the Shraj, former Dean of Business School, University of Cape Coast, the founding Dean, Faculty of Law, University of Cape Coast, former board member, Judicial Training Institute, and currently Director of GIMPA. And we are very grateful to him because he is just lost his father, but he decided to honor this invitation. Ladies and gentlemen, Professor Philip EBOW BONDZI-SIMPSON.
Thank you very much, the Master of Ceremonies. Your Lordship, Mr. Justice Paul Boafo, representing His Lordship, the Honorable Chief Justice, the Honorable Attorney General, President of the Ghana Bar Association, the Dean, Faculty of Law, School of Law now, of the University of Ghana, your Lordships, learned friends, both present and joining us virtually, the media, distinguished ladies and gentlemen. Good afternoon, and I bring greetings from the Ghana Institute of Management and Public Administration. It's still morning, is it? We took a little recess, but good morning. It's my pleasure, my privilege to share a few ideas with you on the topic in question. My topic, which addresses the theme specifically, is why should academics, judges, and lawyers be bothered by continuing professional development when the world is in lockdown? I'm mindful of the time that has elapsed. I will speak to what I have and also mention that I would leave a copy of the PowerPoint slides with the Secretariat, and I believe that in due course, those present in the room will get it. But I do gather that those joining us virtually have it. I will essentially be answering the questions, a number of them, the importance and relevance of continuing legal education. Some will call it continuing professional development. And the committee of the bar here is continuing legal education and professional development. So I'll ask the question of the relevance of that, and I'll use continuing legal education and professional development interchangeably. I would be looking at what a few other jurisdictions have done. And finally, in the light of the Ghana situation, I will be making some specific recommendations for incorporation. But why should we be having continuing legal education or professional development when the world is in lockdown? Is the world really in lockdown? And if so, so what? Let's remember that we refer to ourselves as learned. Lawyers are learned friends, and among the judges, they refer to each other as learned brother or learned sister. And if you are learned, you must continue learning, whether lockdown or not. We do not refer to ourselves as we were learned. We refer to ourselves as we are learned. So learning will and should be a continuing activity, and that should go without saying. But the world moves on. And as the world moves on, we will either be left behind, or we should be moving on with the world, or preferably ahead and setting the pace. So I believe that the first question as to the importance and relevance of continuing legal education is self-evident. It's important for us to develop our competencies and skills and knowledge so that we can continue to render useful, productive service for those who require our services. In particular, the public, the profession, our clients, and ourselves. Continuing professional development or continuing legal education isn't unique to us in Ghana. Other professions here in Ghana do it, and would also be looking at how continuing legal education is also done in a number of selected jurisdictions. In Ghana, we do know that physicians and surgeons and dentists, nurses and psychologists, engineers, pharmacists, and the like all require it for the same reason. The knowledge of yesteryear will be overtaken by the events of today, and we should be preparing ourselves and equipping ourselves for tomorrow. So in a little while, I would be looking at some of how continuing legal education is organized in some of these jurisdictions. But now to the question of the lockdown. And lockdown arises from COVID. And so how has the COVID situation and the COVID dispensation provided the imperative for us to even be considering the question of continuing legal education? I suggest the COVID dispensation addresses this matter in a number of ways. First, we must be looking at the implications of COVID on technology. In other words, because the public health situation has caused social distancing and the like, the opportunities of direct and extensive physical interactions have been much reduced. But the work must go on. Clients must consult their professionals. The professionals must undertake their businesses with the courts. The business of the courts must go on, and technology is a useful aid in all of this. So, for example, e-filings, e-service, and the entire electronic justice framework. Various payment platforms, payment, of course, of fees to counsel, payments for services to court, payments into court, will and should be done electronically. And we have to equip ourselves to do these effectively. the conduct of court proceedings themselves, hearings and the like, to be conducted virtually. It's become more or less the standard or the order of the day in some jurisdictions, where now hearings are conducted virtually. Counsel can operate from their chambers, if properly attired, even from their homes, and be having various court sessions. So this is something that we should be looking at and preparing ourselves for. And the final area that I will touch on is the production of transcripts, transcript production. We've had problems in the past with stenographers and court reporters and recorders trying to take notes in longhand. Both their speed and the accuracy of the transcripts have often been called into question. Thankfully, technology is available to address this. And so, returning to the first point, technology is useful for the administration of justice, and continuing professional development will equip lawyers and judges, paralegals, and court reporters and recorders and the like to avail themselves of technology for the advancement and administration of justice. Chair, for the occasion, the second broad area that I'd like to speak to are the areas of practice that direct and anecdotal evidence suggests have gone up just as a result of lockdown or the COVID area. Some areas of practice have become more prevalent, perhaps even more important because of COVID. Some of these areas are in the area of family law. Both its harmony and its pathology. There have been a number of marriages, and marriages have gone up, and unfortunately, separations and divorces have gone up. As people are locked down, the need for harmony goes up, and in relationships that in the past were simple courting and common law, a good number of them in other jurisdictions got converted or elevated to proper marriages. But at the same time, too, as people stay in their rooms longer and longer, differences manifest themselves, and a good number of problems have resulted in separations and divorces. Areas of family law have therefore become very important in this COVID dispensation, and the bar might as well equip itself better still to handle this area. The second broad area is in wills and estate administration. A good number of people have unfortunately perished. That is fact. So knowing that one could fall ill, or knowing that one has fallen ill, and the possibility could be that arising from that illness, one could meet the maker. Instruction for will making has gone up, as well as areas relating to estate administration. COVID, therefore, will require us, looking at the experiences of other jurisdictions, to equip ourselves in the areas of wills and estate administration. Criminal law. Businesses especially have been hard hit. And as people have been hard hit, when there is hunger and poverty, and when there is the need for survival, unfortunately, these may be addressed in either lawful ways or unlawful ways. The incidents of theft and burglary, robbery, assault, and the like have gone up, and also murder. The discussions over the last little while, last 2-3 days, suggests that not only do we have cases, for example, of murder, even as people are looking for money, they may look for money in ways that can cause occultism to make demands. It therefore becomes necessary for our profession to provide the appropriate opportunities for its members to improve upon and develop their skills and competencies in areas of criminal law and its practice. And so too in the area of cyber law with its associated areas and related areas of commercial law. Labor law. Businesses have faced all kinds of challenges. Compensation issues have arisen, negotiations to reduce salaries and or staff numbers, questions as to redundancy and the like, and employees and others going to the equivalents of our labor commissions and courts. Labor law has been an area that has been significantly on the rise in other jurisdictions, and I would surmise in Ghana also. And finally, intellectual property. Crises create difficulties, but crises also create opportunities. During this period, we've seen that businesses have picked up in a number of areas. The IT sector, for example, has developed itself considerably. Those in the biochemical industry and the biomedical sciences and the production of medical equipment have also picked up. But coming back here to Ghana, we will recall that in the course of 2020, for example, there were social media images of young people who were using metal drums and the like to make basins for hand washing. We will recall that Veronica buckets picked up in sales considerably. A few months ago, Madame Veronica was interviewed because Veronica bucket is named after someone who did it, who is still alive. And her regret was that while Veronica buckets have picked up in sales, she didn't patent anything and has not got a PESWA, despite the success of Veronica buckets. What I'm talking about is aspects of intellectual property law. And in particular, that aspect of intellectual property law that deals with inventions and processes, patent law. As we develop our practice and we branch into intellectual property law, we will see that we will be more useful to country and to client. And so I'm suggesting the first area of importance is as we look at how COVID has affected the nature of the practice. And this second area is in specific specializations that have improved during the period. But continuing legal education, even during this lockdown period, should require us to keep ourselves abreast with the law. And to be current in the law, we should be looking at specifically legislative and decisional law, perhaps over the last 5 years. So as part of our continuing professional development, continuing legal education, we should see how the law has improved or from decisions of our superior courts. And I'm suggesting that as we do this exercise, we will see that there are a number of areas that the bar may wish to be looking at for topics or modules or seminars in these. I'll just mention a few of them in the legislative and a few in the decisional law area. And in the interest of time, I would move on. Some of the areas in the legislative law, for example, will include property rights of spouses, right to information, the National Intelligence Bureau, what previously was the Bureau of National Investigations, has changed. And what does it mean? And what do they do? And how is it structured? And how will it affect our clients? Company law. There's been a recent enactment of the Companies Act. The enhanced jurisdiction, monetary, substantive, and otherwise, of all of our courts, notably the lower courts, African continental free trade, and the like. So there are specific areas that should interest us. And as we look at them through legislation and international treaties and the like, we would equip ourselves as judges, as lawyers, and as academics so that we are abreast with current developments. The same, Mr. Chairman, goes for the decisional law. Very recently, as slightly over 8 years ago, something also similar happened. We received the unanimous decision of the Supreme Court. It would be important for us to digest it, analyze it, appreciate it. What should we be gleaning from our law courts, say in areas of contempt of court? And as the president of the Bar Association spoke about, a suggestion has been put forth, which I have noted, and I will suggest also for kind consideration, which is overcoming the pitfalls in invoking the supervisory jurisdiction of the Supreme Court. So there are a number of things we could be looking at emerging from court decisions, emerging from international and domestic legislation and the like, that will be important modules or topics for the development of the profession. Mr. Chair, permit me now to do a very quick survey of how continuing legal education and or professional development is conducted in a few countries. I'll be looking very briefly at Nigeria, Kenya, South Africa, the United Kingdom, a province in Canada, Ontario, and a state in the USA, New York. I would speak very briefly to what I have and not necessarily touch all of the points. In Nigeria, since 2007, there's been mandatory continuing legal education. It's organized every other year biennially, and it is required, therefore, that during this period, the lawyer will do 30 hours, on average 15 hours a year, but for the benches, and the benches are the officers of the Bar Association, those who run it. So for the senior advocates of Nigeria and for the benches of their Bar Association or Law Society, they will have a reduced one of 24 hours, which averages 12 a year. Kenya's is most comprehensive of the jurisdictions surveyed. It's incorporated in law, both legislation and subsidiary legislation. The legislation of the equivalent of our Ghana School of Law or our Board of Legal Education requires professional development at all levels. So it is factored into the legislation itself. And in section 4.1, it says it shall be the public legal education provider responsible for the provision of professional legal training as an agent of the government. And in 4.2, amongst its other functions, it shall ensure continuing professional development for all cadres of the legal profession. So they've put it there in the legislation itself. And in subsidiary legislation, it has spelled out in detail a number of things, including how it is to be delivered, methodology, certification, and the like. In particular, with respect to methodology, it's section 19 says, training methodology shall be interactive, shall be through interactive lectures, group discussions, plenary discussions, skits like short plays, role playing and simulations, demonstration exercises, debates, and roundtable discussions, attachments, and study tours. Then there are other provisions, as we said, as to its delivery, assessment, and there's certification. In South Africa, there's nothing set out in legislation or subsidiary legislation, but continuing professional development takes place by way of practice and convention. In the United Kingdom, particularly for the solicitors, there's been the fairly recent establishment of the Solicitors Regulation Authority. It's the rough equivalent of a general legal counsel, and they require the solicitor to develop themselves, and on the pain of sanction, file a declaration. And that declaration shall be to the effect that they have developed their competencies as reflected in their practice and through regular learning and development, so that they have now possessed the skills and knowledge which have brought them up to date. You shall file that declaration. They leave it to you to declare, and woe unto you if you make a false declaration. It's largely an honest system with a whip attached to it. Do we have teeth? Do we have an appropriate sanctions regime? In Ontario, in Canada, which is its largest province, again, while there's no express provision, they also, through convention and practice, have it, and they have the 12-hour per year continuing legal education split into the following: 3 hours mandatory, everyone must do that, and it's on topics related to professional responsibility, ethics, and or practice management. Then 9 hours elective is compulsory, you must do it, but it is not compulsory which elective you will do. So if your practice interest or area is in family law, is intellectual property, or is in criminal law, then you can choose to do it in that area. And in those in general practice, they sometimes will have 2 or 3 broad areas to select from. But they have 3 hours where everybody has to do something in ethics and professional responsibility. The New York bar, which is the equivalent of the Canadian one, that is the largest bar and the most diverse, has the continuing legal education component split into 3. They have 3 hours for ethics and professionalism. They have 6 hours for skills, interviewing, note-taking, communications, and the like, emotional intelligence skills, the things that you are required to possess. And then hours for law practice, management, or professional specializations. What do we have, Mr. Chairman, here in Ghana? Of course, we are mindful of the provisions of both the Legal Professions Act and the Professional Ethics and Etiquette Rules and Regulations and the like. In Ghana, the Board of Legal Education is what offers professional legal education. The Ghana School of Law is actually the Board of Legal Education. So we have that, but the Board of Legal Education or the Ghana School of Law is established by law for the purpose of preparing and training students to become barristers and solicitors. That is what the law has mandated that to do. We also know that while we've got a very vibrant and strong Ghana Bar Association, the Bar Association is a voluntary body. It is not the professional regulator. The professional regulator is the General Legal Council. There may be a close partnership between both, but it is indeed the General Legal Council and not the Bar Association that runs the profession and regulates the profession in this country. We are mindful that a decade and a half or more ago, when following the Nigerian example, which itself was following the British example of taking silk, a few people had been conferred with the honor and degree of Senior Advocate of Ghana, one fairly, a very senior lawyer, took the matter to court, and the court ruled. So we all know that the Ghana Bar Association is a voluntary association. The professional legal education and professional development programs, which we do, are very beneficial, but they are not mandatory. And it goes without saying, and it is to state the obvious, many people routinely get their practice license renewed annually, whether or not they have done any professional legal education module. What, therefore, Mr. Chair, are the recommendations I will put forth? Let me take a step back to support the case for continuing legal education and/or continuing professional development, and that it should be mandatory. This is so because the knowledge, skills, and competencies are required to be possessed and improved on a consistent basis. So I support that. And if that is the way to go, then how do we make it effective? My first suggestion, therefore, is for legislative backing Of the various jurisdictions surveyed, I've indicated my preference for the Kenyan model. We can tweak it to suit our circumstances, but there ought to be legislation which will back it. The second thing is that after there's legislative backing, there should be a locus invested with that responsibility for conducting sound professional legal education. The Nigerians have an institute of the bar, but if the bar itself presently is a voluntary association, then making it an institute of a voluntary association may not grant teeth enough. Either the bar has to be elevated to be the professional regulator, or if not, this responsibility should be given to a unit of the professional regulator. The Board of Legal Education is under the authority of the General Legal Counsel, and I will therefore suggest as my second point that that locus should be the Board of Legal Education. It's presently headed by a director. It perhaps should be elevated to a director general. SNET and the like previously had the same, Ghana Education and the like had the same, they are directors general. GTech had an executive secretary, it's been elevated to a director general. Where I am now started with a director, and then the head of the institution became director general, and then he had directors under, and then now the head of the institution has the nomenclature changed. There is something in that elevation which grants authority, and as we now have a director general for legal education, we can have a director responsible for the delivery of the law school courses. And we can have another director responsible for the delivery of professional legal education. The director who is responsible for the delivery of professional legal education should not think that the resource persons required for the training delivery should necessarily be the full-time lecturers associated with that division. Like a good institution, there has to be the development of a very rich resource bank, depending on the subjects, on the bench, the bar, in duration of 15 hours, I will not mind 12. But I'll suggest 15 split, 3 hours for professional responsibility and ethics, much like the New York and the models at my profession. Another 3 hours for practice management. And if you are in practice in a private law firm, the dynamics may be different from if you are in practice at a legal department of a statutory corporation or metropolitan municipal district assembly or the like. And those dynamics may also be different from if you are in one of the agencies under the Ministry of Justice. So state attorneys may have a different arrangement and module and the like. So 3 hours for professional responsibility, another 3 hours for practice management, and 9 hours for substantive law, and that will include procedural and adjectival law in areas of interest. So if your area of interest is immigration or is in land law and conveyancing and the like, there will be those areas available to you. The country, I will suggest, should be zoned for delivery whether delivery is going to be in person, which has become a necessity under this dispensation, and I will associate myself, Mr. Chair, with the observations and remarks that the online delivery has now become a necessary complement. But whatever the case is, effective learning can take place when you are delivering a plenary to 300, 400, 500 people or 1,000. So beyond that, the country can be zoned into different zones, and whether a module or a unit will have 20, 25, or a maximum of 50 people, whether in person or online, sure that effective learning is taking place. It is indeed the case, as he observed, that even with online, you can turn it on, put the video off, mute it, and do your own thing. But if we are interested in learning taking place, we should be interested in a format that will guarantee that learning takes place. And therefore, I suggest a zoning and a cap of numbers for the delivery of the different modules. Training methodology should be varied, and a number of them have been listed, and I will not repeat them again when we looked at the Kenyan subsidiary legislation. There should be annual or biennial certification depending on the way we go. And it should be a requirement also for license renewal. Continuing legal education should not be treated as cash cow, but cost recovery with a little margin. So something for the organization, something for the module preparation, something for stationery, and so on and so forth. And then perhaps a little margin, pure cost recovery, and you can cover costs and have effective learning taking place. Mr. Chairman, I will be bringing my remarks to a close by concluding as follows. Continuing legal education and professional development is necessary, even under lockdown, if we have lockdown. I will commend the Ghana Bar Association for what it has done thus far in embracing continuing legal education. Indeed, several years ago, I happened to also be on the continuing legal education and professional development committee of the Ghana Bar Association, and I was privileged to chair it. And it has done well, and where credit is due, credit must be given. But more can be done, and more should be done. I have made it abundantly clear, and I wish to repeat them in my concluding remarks, that to grant teeth and ensure results, it requires statutory backing. And as it gets the statutory backing, the locus should be identified, which I suggest to be the Ghana School. With these remarks, I hope I have addressed the topic of your attention, and good morning.
Thank you very much, Professor BONDZI-SIMPSON. Prof, there are there's a question for you. Yes, via Zoom from Nick Nickelton Kumoji. And the question is, your delivery has been pertinent in matters that affect the ordinary man. The enforcement of the law needs to be strengthened in areas of armed robbery, burglary, scamming, and violence against the person. What are your sentiments on these matters? That's the question.
If it is a crime, it must be legally stipulated. And if it is a crime, it must be investigated, persons prosecuted if there is a case to make before the court. And if conviction is registered, penalty prescribed by law must be imposed. If with the passage of events, things that previously were crimes now have to be criminalized, or things that are now crimes should be decriminalized, that exercise can take place through advocacy and through parliamentary interventions. But if it is a crime, there are agencies of state to investigate, to prosecute, to try, and if convicted and jailed, to receive into their custody those persons jailed. The mandate on us as a country is to ensure that the institutions of state and public officers do their work. But the law should take its course. Thank you.
Michael Akuya is asking, very positive presentation on continuing legal education. My question, however, is which body should be responsible for the CLE? Should it be the Ghana School of Law or the Ghana Bar Association? Note, however, that GBA is a voluntary association. This from our sister Victoria Bath. This Rule 84 of the Legal Professional Conduct and Etiquette Rules, LI 243, now makes continuing professional development mandatory. Every lawyer who holds a practicing certificate has to complete, I think this is more of contribution. The provision is, however, not exhaustive, as a commendable recommendation being made by Prof. So hers is more of a contribution. So that Michael Akuya is the only question for you to answer.
Thank you. Before I answer or attempt to answer Michael Akuya's question, let me acknowledge the import and essence of the second contribution, which reinforces something which the president of the Ghana Bar Association made about compulsory continuing legal education. I wish to stress that that is so. There's always, however, the differentiation between de facto and de jure. What is written, and what is done or not done is done or not done. So we want to now try and transition from the what is written. So I think the discussion which we should be having is, how do we convert a mandatory provision, de jure, to a factual operational arrangement so that infraction will result in consequence? That's the de facto. And I believe that it's a useful conversation to be had by all of us. I should also mention that I am aware that the Judicial Training Institute also endeavors to develop the capacity of magistrates and judges for the same reason. For the same reason. And sometimes, depending on a geographical area, a training module will be developed for the judges and magistrates in that area because an issue arises, or depending on the season in question, for example, election season, training may be done because there's a possibility that there will be petitions, either parliamentary or presidential. But where do we have it across board? Not only for all lawyers, but also for all magistrates and judges so that they develop the necessary competencies, professional skills, and knowledge. So that I wish to say, and it's just building on this. In respect to the question to me, I must apologize if I didn't make myself clear. And therefore, as the legislative drafters will say, after you've written it in a certain, then you say it a certain way for the avoidance of doubt. So my own view is that for the avoidance of doubt, the locus should be identified. The present position is that the Ghana Bar Association is a voluntary association. That's it, the present position. In the past, I'll move away. Let's go to teachers. Teachers, we had NAT. Then out of NAT, NAGRAT came. They said we are professional teachers. The teachers at some point in time, and it was a case that went to court, endeavored to levy teachers a certain amount of money, and somebody took it to court and says it's a voluntary association. You cannot impose any levy on us. A levy is either by consent or by legislation. The Ghana Bar Association from the Wardbrew case is no different. So even though my heart is with the Ghana Bar Association, for the avoidance of doubt, my head is with the General Legal Counsel. And the General Legal Counsel, because it is the professional regulator, and by law, the General Legal Counsel has ceded that responsibility to its division or unit or agency called the Board of Legal Education, aka Ghana School of Law. So it is easier now for that to be done than it is to make it mandatory for the Ghana Bar Association to be the body. But if through advocacy or otherwise, as for example happens in New York, the New York Bar is not a voluntary, but a professional regulator. If we then have the New York Bar becoming the body, it probably will be the tidier place to be. So for the time being, Mr. Akowa, my view is that the locus must be identified, and I've suggested that locus to be the Ghana School of Law for the reasons I have set out. Thank you.
Now, as Prof said, for the avoidance of doubt, I'll read section 84, 1 of the Legal Professional Conduct and Etiquette Rules 2020. 1. A lawyer who holds a practicing certificate issued by the council shall A, complete a minimum of 12 hours of continuing professional development in a calendar year, and B, submit details of the continuing professional development undertaken to the council in the form prescribed and at the time specified by the council. 2, the council may by resolution specify the nature, content, and format of the courses and other activities which may be undertaken by a lawyer or a category of lawyers in order to satisfy the requirement of continuing professional education. 3, the council may, by resolution and following consultation with other bodies as appropriate, increase the minimum number of hours of continuing professional development. Now, at the General Legal Counsel, this now has become a mandatory requirement for the issuance of the license. And as Prof said, Now we should look at the sanction regime. How do we ensure? Thank you very much.
Thank you very much, Professor Philip Ebu BONDZI-SIMPSON. That brings us to the end of the morning session, and we had 500 participants joining virtual. 500 and more will join us in an hour's time for our afternoon session. Work-life balance in contemporary moving Swansea ACN lecturer, Faculty of Law, University of Cape Coast, and the speaker, Dr. Edwina Beryl Adu Opari Loco, Senior Specialist Family and Palliative Physician, Greater Accra Regional Hospital. The second session will be what was referred to by both the National President and Professor Simpson in their presentations, pitfalls and applications. The moderator will be Mrs. Susanna Futu, Lecturer, Central University, and the speaker will be Justice Gabriel Kwamai, Justice of the Supreme Court. Thank you very much. We'll see you in an hour's time. Thank you. We'll rise for the closing prayer by Her Ladyship Justice Efia Sewa Asari Buchi.
Especially, my Lord, please, if I may stand on all the previous protocols, shall we pray? We thank you, God, for our work as administrators of law on the bench, at the bar, and as a faculty. Father, we thank you for what you have taught us this morning. We pray for all of us, for the renewal of our minds, and for a spirit of excellence. We are also praying for better days ahead in our work. Father, we pray for the rest of the conference that at the end of it all, we shall see a great improvement in the delivery of justice. Lord, dismiss us with your blessings. Through Christ our Lord. Amen.